to have 250458, Klein versus Whirlpool Corporation. We'll let you folks set up. Mr. Wertz, you'll be arguing for Mr. Klein, and Mr. Smith for Whirlpool. And whenever you're ready, we are.
May it please the court, counsel, court staff. My name is Tom Wertz, and I represent Brian Klein on his claim for workers' compensation benefits. This is a case where the commissioner, as the finder of fact, went outside the record in his determination of the impairment rating for a distal clavicle excision. We know that with a jury trial, a juror wouldn't be allowed to bring in evidence outside what was in the case to make a determination. We know with a bench trial, the same is true. A judge wouldn't be able to bring in evidence from the outside for determination. Same thing in a medical board. A member of the medical board wouldn't be allowed to bring in evidence outside to make a determination.
Counsel, specifically, are you indicating the outside information is the use of the AMA guides?
The outside information I submit is that, yes, the AMA guides. I don't think the AMA guides, I think the AMA guides are evidence. And that in this case, what was submitted at the time of the hearing, no party submitted any of the pages from the AMA guides, and specifically it'd be chapter 16 that dealt with the upper extremity. And no party asked for official notice or judicial notice of the AMA guides. What we have is what the guides say, or not the guides say, the statute says, that these determinations are supposed to be made upon 8534-2X, which indicates that impairment ratings are the province, basically, of physicians. And it specifically says that the agency shall not use agency expertise. And so,
In this case, it talked about the 25% multiplier. Was there any expert in this case that talked about applying the 25% multiplier?
there are three opinions in this record: Dr. Bollier, Dr. Taylor, and Dr. Broghammer. We know that in 2020, Dr. Bollier provided the first opinion as a physician, which it was based upon solely on range of motion, did not discuss the distal clavicle excision. 2020, Dr. Taylor provided an impairment rating based upon both the range of motion and the distal clavicle excision. 2023, 3 years later, Dr. Broghammer provides a report, and his report deals solely with, as far as his opinion of impairment, range of motion. So the only evidence in this record pursuant to the statute is that of Dr. Taylor and the distal clavicle excision, nothing about the use of the 2.5 multiplier, which reduces the impairment rating from 10 to, or from 10% to 2.5, and which makes a big difference for the injured worker from the standpoint of 40 weeks versus 10 weeks.
So the range of opinions is 4%, 15%, 2%?
Well, no. Sorry, specifically, and I don't have it in front of me right now, but Dr. Taylor would have done 10% for the distal clavicle excision plus the range of motion and done a combined rating. The other ratings were solely based on range of motion by Dr. Broghammer and Dr. Bollier.
But the range between the three experts is a low of 2% to a high of 15%. Okay. And the ultimate decision by the commissioner came in within that range, right, at 9?
Say that again?
So we have doctors that give anywhere from a range of 2% to 15% for the impairment to the shoulder. And the ultimate decision by the commissioner was 9%, correct?
Yes, but it was predicated,
I understand you have a problem with the methodology of how we got there, and I understand that, but
he's not a physician. The methodology and the fact he's not a physician.
no, I understand that, but it is within the range of that, at least the 2 to 15 on bare numbers. Okay.
Numbers make a big difference as far as Brian Klein's concerned. So what we submit is, on October 23rd, 2023, the Deputy Work Comp Commissioner clearly stated that, all right, then this case will be considered fully submitted as of today, October 23rd, 2023. The record will be closed as of today, October 23, 2023. So in our case, I would submit that the commissioner has tried to sort of backdoor this concept of using the multiplier through what he, is considered the J decision. So what's happening is anymore is with cases with a distal clavicle excision, they're just saying, agency precedent is the J decision. Now, if we look at that J decision, step back and in that decision, once again, there isn't, the distal clavicle excision really isn't a component necessarily. You have two competing opinions with regard to Dr. Taylor and Dr. Vincent. It's the commissioner who, involved himself in that, applying this multiplier.
Did I understand your brief correctly that, and it struck me because it seemed like a very stark, candid pronouncement. If I'm understanding you correctly, you're taking the position that the commissioner has a choice when you have competing experts of either following expert A's opinion or following expert B's opinion. Correct. Those are the only two choices available to the commissioner, because anything else would be using their agency expertise. How do you reconcile that with all our case law that says a fact finder can believe all, part, or none of any witness's testimony? How does it become an all or nothing thing? Either you accept expert A that said 2%, or expert B that said 4 or 5%, or expert C that said 15%. That's the menu you have to choose from.
It says that the ratings of permanent physical impairment are to be provided by a physician using the 5th edition of the AMA guides, and is explicit with regard to the fact that agency expertise is not to be used.
So, we've all been there. We've had cases where we're questioning an expert and they pull out these AMA guides and they actually did the math wrong. So we can't, the fact finder can't say, this is wrong.
My argument would be that, this is an adversarial situation. You've probably read the decision of the commissioner, and he gives some examples that he feels like, well, if there's some absurd result, we need to correct it. Well, first, he's not a physician. How does he know what the result should or should not be? Plus, this is an adversarial situation from the standpoint there is another party involved, and that's, in this case, obviously the defense attorney. If there's some absurd result with regard to a physician, no doubt the respective party would deal with that with regard to a physician's opinion.
Kind of springboarding off Judge Greer's question, if the claim of the defense is, hey, you miscalculated using the guidelines, you did a math error on this, they actually have to call an expert to say, I think they did a math error on this, and this is why. So the defense would have to call an expert to say that, as opposed to the fact finder can't just say, hey, look, I find that they did the math wrong based on the cross-examination questions or the direct exam questions, and just correct that math error. Is that what you're saying? You have to have the expert attack it?
I'm saying that, well, one, that this isn't necessarily an issue that you would have to decide today, because we're just saying that essentially our argument is that he's brought into evidence this distal clavicle excision, which is not in evidence, using the ultimate multiplier.
There is evidence in the record that there's this DCE. In fact, that's uncontroverted, right?
That he had the surgery for the distal clavicle excision, that's uncontroverted.
So unlike the Harrell decision that you rely heavily on in your briefing, where there wasn't any evidence of a knee replacement, and yet they relied on the knee replacement in applying the guidelines, that's different, right? Because here we actually have evidence, and it's uncontroverted evidence, that there was a DCE. Right.
And the
Make it different than Harrell?
No, I mean, the implications here, I would say, is that if, say, for instance, in a case, there's evidence of a DCE, and no party gets a rating, is it the agency's obligation or duty then to award an impairment rating for the distal clavicle excision? I mean, I would say if this decision holds or the J decision holds as the commissioner has provided, then yes, in fact, I think we've complicated the whole process, and now we're going to put an affirmative duty on the agency to award impairment ratings without any physician's opinion.
Your time is up, and you'll have more time on rebuttal for more questions. Thank you very much. Mr. Smith?
May it please the court, opposing counsel. I want to start with how we finished, and that was if there's no impairment rating, there's an affirmative duty on the commissioner to award one based on the AMA guides. And that is not the case today, and that's not what I believe the evidence shows. The evidence shows there was a distal clavicle rating. There was a 10% given by Dr. Taylor, and the deputy first adopted that, and then the commissioner affirmed that.
You have to have some evidence in the record, some testimony from an expert or a report from an expert to apply this 25% multiplier. Why does the commissioner get to do that on its own? Well, I guess my first question is there any evidence, this plays off Judge Greer's prior question, is there any evidence in the record that about the 25% multiplier?
Yeah, so the evidence in the record on this case is there was there was a treating orthopedic surgeon, Dr. Bollier, who did not find any impairment for the distal clavicle, right? So the absence of impairment, he didn't find impairment. So when he evaluated the claimant, he opined on the impairment rating without asserting an impairment for the distal clavicle. Dr. Broghammer, defendant's or Appellee's expert witness, provided the same, right? He did not find a distal clavicle impairment rating. He found impairment to the shoulder.
Motion.
Right. He, utilizing the guides, the in-person examination and so forth, he didn't find a rating to be applicable to the distal clavicle. Neither opined on a rating to the distal clavicle. Dr.
So by implication, neither one of those two experts applied the 25% multiplier.
Right. They did at zero, right, because there's no rating. Dr. Taylor found an impairment rating for the distal clavicle, which was 10%. The J decision had already come down prior to our arbitration hearing. So we went to arbitration hearing with the precedent of the commissioner saying if there is a rating to the distal clavicle, the commissioner will utilize the modifier. That was already the commissioner's precedent.
Was there evidence presented by an expert to apply the 25% multiplier?
No. What the commissioner did is the commissioner utilized the framework of the AMA guides, and under that framework of the AMA guides, he applied the law to the facts and said the modifier should be using. Interesting, Iowa Code Section 8534-2X, which is the controlling statute for the impairment rating, counsel indicated that it must be by a physician. Nowhere is there physician in the language of that statute. The impairment rating isn't automatically in the domain of a physician because that's not what the statute says.
That specific statute also has the language lay testimony or agency expertise should not be utilized you don't put the 25% qualifier in that agency expertise?
No, it's enforcing the rules. It's enforcing the guides. So the guides are specifically mentioned by the legislature, right? It says solely by utilizing the guides.
Is right there the reason no one had to ask for judicial notice of the AMA guides?
The burden is on the agency to utilize the guides to determine the impairment rating. There can be evidence of what those impairment ratings should be, and one of the areas of evidence is an expert report by a physician. It doesn't demand that a physician gives the impairment rating within 8534-2X. What it says is it shall be determined solely by utilizing the guides to the evaluation of permanent impairment published by the American Medical Association, is adopted by the Workers' Compensation Commissioner. So everyone who practices before the agency understands that the impairment rating is utilized by the guides.
Just a little differently. Is there any medical evidence required to apply, other than the diagnosis that's before us, to apply this multiplier? Or is it simply part of the AMA formula?
AMA guides has a subsection within the utilization of the distal clavicle that goes on to define exactly how the loss of strength, the severity of impairment due to these disorders is rated separately according to tables 1619 through 1630, and then multiplied by the relative maximum value of the unit specified in tables 16 through 18.
Does that require a medical diagnosis?
No, it requires the 10% distal clavicle rating. Once you have the distal clavicle impairment rating, the modifier can be applied. And so the commissioner can take the 10% and go to the guides and obtain the modifier usage.
If the fact finder finds that there has been a DCE diagnosis, that by operation of the guides mandates the 25% multiplier.
Commissioner held, yes, the commissioner found that the guides do apply the modifier to that distal clavicle evaluation, or impairment, excuse me.
The court's decision says, quote, petitioner contends that because there are several ways to interpret the use of the multiplier regarding distal clavicle excision, the fact renders it a judgment call of a physician and not subject to agency expertise. Talk to me about that.
This goes to the enforcement of the guide. So the evidence was presented to the commissioner about the utilization of the guides, right? In J, the distal clavicle rating, no one specifically, he looks to other authorities in J, including a report by Dr. Klein, for his rationale in support of why the guides would utilize the modifier. And because of that framework, he adopts the modifier as used for the distal clavicle in J. And thus, what he's saying is the evidence that was presented and the expertise from the medical professionals, I've arrived at the right answer, the conclusion of the guides is this.
Percent a given? If there's going to be a multiplier, it is 25%, or is there a range up to 25%?
I believe it's 25% firm. I don't believe there's a range of modification. I don't know specifically without having the guides in front of me.
If it is a range, wouldn't you need some expert evidence on which number in the range should be used before the commissioner could find a number in the range without relying on the commissioner's own expertise?
I think it's the totality of the record. The expert would obviously be a support to that conclusion, but I think the record can't be isolated just to an expert. You know, the statute doesn't create the domain to the expert.
How if and I don't know that it does, but if the guides say, hey, look, if you have a DCE, you need to do a multiplier from 0 to 25%, just to make up something, right? I have a tough time seeing how they can just pick 25% or 10% or 15% without some expert saying, here's why it's 10, or here's why it's 25, or here's why it's 0.
Right. I mean, I concede to that point. If it's a range, it puts a higher burden on the evidence to show why that range should be adopted for the commissioner, not to insert his own expertise. But the commissioner obviously has the ability to accept in part, accept in whole the records or the evidence throughout the whole record regarding that, including the expert testimony, to arrive to the conclusion of that range. They can look at the medical records, they can look at the testimony. It's not just precluded to utilize the guides. It says we must utilize the guides. The lay evidence and agency expertise, he's inserting the enforcement of the guides, not his own expertise of the guides. He's saying this is what the guides say, so we must enforce it. He's not using an expertise or lay testimony to support that. He's using the guides itself to render the outcome. He's, he's the enforcer of the guides. He's the adjudicator of the decision, not the physician or not the expert.
Broader picture, when we're deciding these decisions, we try to think of our impact on future cases. If we were to adopt the appellant's position that you had to ask for judicial notice to apply the AMA guides, what would that do to the consistency of these types of cases?
I think it would add confusion and delay, or just, the guides are in the statute that we should utilize them. Everyone can read 8534-2 and understand the guides are there, or the administrative rule that they are there. It's been long-standing tradition that we use the AMA guides to fifth impairment to derive an impairment rating. We don't use the 6th edition, we don't use the 4th edition, we don't use the 3rd edition. So I don't think there needs to be official judicial notice from the agency or from counsel to assert the use of the guides. We had legal precedent going into the arbitration hearing that the commissioner was going to utilize the modifier. He had already ruled on that in J prior to our arbitration hearing. If the appellant thought that modifier was erroneous, then why didn't Dr. Taylor speak to it? Why didn't his expert provide evidence that he thought the modifier was incorrectly interpreted or incorrectly adopted by the agency?
So, sorry. You can wrap up if you need to.
You'd affirm the district court's decision. Thank you.
Rebuttal?
I mean, one of the first points I'd make is that in this case and the other cases, in this case, you've got Dr. Taylor's unrebutted opinion. In the J case, there was basically an unrebutted opinion by Dr. Taylor. One of the cases that that the commissioner cited to in the J case, there was an opinion of Dr. Napola at the University of Iowa. It's 10%. So we've got 10%. We've got the 2.5%. Sometimes they say you've got to round up to 3%. I'm submitting in this record that there are variables from physicians, and in this situation, the commissioner doesn't have a right to choose one. I mean, it's the physician's opinion.
Going back to the question I asked opposing counsel, as I understood the commissioner's ruling, leaving room for the possibility I'm misinterpreting it, I took it to mean that there's a table in the guides that says if there's a DCE diagnosis, which there clearly is, that there needs to be a 25% multiplier applied. Not a range, it is by fiat a 25%, right? Is that the case? Is that what the table or the chart within the guide says, or is there a range, or what's your thought on that?
It's chapter 16, and then there's a subchapter that deals with this. And there's a table that says with distal clavicle excision, you get 10. And then there are all kinds of other tables in there. And some of those other tables in that same chapter have an asterisk under them that say, apply the multiplier. Now, this table does not say apply the multiplier. I think this...
Is that multiplier 25%?
It's 25%, and then there's kind of a rule that...
Just a direct number. It's not a range up to 25%. It's like, if we're going to apply the multiplier, it is 25%. Okay.
round up.
Sure.
So some decision...
The commissioner did, right? The commissioner did round up from 2.5 to 3 to get up to the 8. Is that what it was?
Yeah. So I think the danger in this case, though, is that when, on that appeal decision, the commissioner talks about that the AMA guides are like the law. And I don't think you want this to be the law. This is a for-profit book.
Legislature kind of made this decision, right? They said,
Use the AMA guides for ratings.
the reason they did that, as I understand it, at least the argument is that they wanted more uniformity in work comp decisions. And so they were going to require that you use that. And so your argument, if you look at, if we're talking about what this is going to do down the road, doesn't your argument do away kind of with the legislator's purpose of trying to get, okay, use this and we're going to use this and not have to worry about what the experts say or don't say as long as they do the medical part? But the application of the AMA guidelines will be our guide.
When you look at legislative purpose, in our appeal decision from the commissioner, he says this agency can and must use agency expertise to read, interpret, apply governing law and standards adopted by law and administrative rule. If we're going to take that literally, then what meaning does 8534 2X have when we say shall not use agency expertise? He says, I mean, it's made that statute meaningless.
Meaning of that statute to say, hey, look, everything's anchored on the guides, right? So the commissioner can't come in and say, yeah, I know the guides say it's 15%, but you know, I look at this and he's got this type of range of motion issue and he has this DCE, so I find that his impairment's 30% or 5% or whatever. The thing has to be anchored to the guides, right? So it doesn't make it meaningless to apply the guides. By my take on it, applying the guides is more of an art than a science, even though it's supposed to be scientific, right? You agree or disagree with that? And I only say that because given the differing opinions.
I mean, I feel like the AMA guides is like a dartboard. They just picked out numbers to assign to things.
And well, and given the fact that you have competing experts to say, hey, I've applied the guidelines and I get 2%, and another doctor comes in and says, I've applied the guidelines and I got 15%, leads me to believe that these things that this isn't the math problem that we think it should be, right? It's more of an art.
The commissioner, yeah, I think that you're going to be presented with physicians' reports, and you're going to have to make a decision as to who's more qualified, which position is more acceptable. You know, what do they explain as to what they did with regard to range of motion? And I think they're going to have to choose a doctor, choose a report.
Thank you.
Thank you. We'll consider 250458 Klein versus Whirlpool Corporation submitted. Counsel, thank you for the excellent arguments today and the briefing. And I'm sure my colleagues and I will get a decision out to you as soon as we can. Thank you very much.